webinar series. In this webinar series, we are examining arbitration laws of important arbitration venues. Undoubtedly, one of those venues is Switzerland, and we have a leading young practitioner who would be dealing with Swiss law, Swiss arbitration law. We have Dr. Daniel Durante from Patocchi and Marzolini. He will review arbitration year review of 2023 of arbitration law of Switzerland. Dr. Durante is a partner at Patocchi and Marzolini in Geneva, Switzerland, where he practices as counsel and arbitrator. He can argue case and conduct proceedings in English, French, Italian, and German. Daniel specializes in the resolution of disputes involving civil engineering projects, including offshore drilling, pipeline, port infrastructure, construction of machinery for plants, and advanced technical equipment. He has represented clients in a wide range of industries such as oil and gas, hydroelectric power, defense, optoelectronics, aviation, flower and fragrance, pulp and paper, tobacco, pharma, luxury, and finance. He also represented international federations, high-ranking officials, and athletes in sports disputes before international adjudication bodies and before the Court of Arbitration for Sports in both appeal and ordinary proceedings. He has been serving as arbitrator in proceedings governed by the ICC rules and the Swiss rules in Switzerland and abroad. In addition, he wrote a PhD thesis in law of contracts in Switzerland. Daniel, the floor is yours.
Well, thank you very much for the kind introduction. It's a real pleasure for me to address this audience. I have prepared. I'm going to use a presentation because I think that it's going to help you follow what I'll be discussing today, which is, as was already announced, the case law issued in Switzerland last year in the field of arbitration. Let me start the discussion putting some framework behind it, because there are a few important notions that I would like to address before I go into the cases. The first notion is that arbitration in Switzerland is divided into two categories. On one hand, there is international arbitration, which is governed by Chapter 12 of the Swiss Federal Private International Law Act, or the PILA for short. These provisions apply where the seat of the arbitration is in Switzerland, and if at the time when the arbitration agreement was entered into, at least one of the parties did not have its seat in Switzerland. On the other hand, there is domestic arbitration, and those arbitrations are governed by the third part of the Swiss Code of Civil Procedure. Now, in essence, an arbitration is domestic if it is not international. I will be focusing on international arbitration, but it is important to note that in both categories, the sole court of competent jurisdiction to hear challenges against awards is the Swiss Federal Supreme Court. The second point I wish to raise is that there are two means of recourse before the Federal Supreme Court: setting aside proceedings and revocation proceedings. And I should also add that some case law on arbitration also arises when an award debtor resists the enforcement of an award in Switzerland. So back to setting aside proceedings and revocation proceedings, starting with the setting aside proceedings. An award may be set aside in Switzerland only on the basis of the following 5 grounds for appeal. which you see on the slide. So number one, the tribunal was improperly constituted. Number two, the tribunal lacked jurisdiction. Number three, the tribunal issued a decision awarding more than what was requested or omitting to decide on a prayer for relief. Number four, the tribunal breached the party's right to due process and equal treatment. And finally, number five, the award runs against public policy. Now, with regard to revocation proceedings, there are here three grounds upon which an award may be revoked. Firstly, where the applicant, after the award has been made, has become aware of important new facts or found conclusive evidence that it was not able to allege in the arbitral proceedings. However, these new facts, which occur after the award, are excluded. And what is important to note also is that these facts or evidence relied upon by the applicant must be relevant. So in other words, they must be such that if proved or admitted, they would alter the facts upon which the award was based. Secondly, an award may be revoked in cases where criminal proceedings have established that the award was influenced by a criminal offense to the detriment of the applicant, even if there is no conviction in the end. And if criminal proceedings cannot be pursued, proof may be furnished by other means. Thirdly, and finally, the applicant may bring revocation proceedings if it uncovers circumstances that cast doubts on the arbitrator's independence and impartiality. Now, after this crash course on the means of recourse, let me give you a few statistics about the year 2023. 2023 saw a total number of 73 cases dealing with arbitration in general. In terms of languages, 39 decisions were issued in German, 32 in French, and 2 decisions were issued in the Italian language. 63 decisions concerned setting aside proceedings, and of those 63 decisions, 52 were international arbitrations and 11 were domestic arbitrations. Revocation proceedings were brought against only 1 award last year, and finally, 9 cases fell under other categories, and these are mainly decisions stemming from enforcement or attachment proceedings in Switzerland based on an arbitral award. Of all of these 73 cases, 60 applications were rejected, 12 were withdrawn, and only 1 was granted. So you immediately realize that annulling an award or resisting the enforcement of an award in Switzerland is extremely difficult, at least looking at the statistics. I will not address all 73 cases, obviously, not only because I would probably need an entire day, but also, and perhaps even more importantly, because most of them are not particularly interesting. So what I've done is that I've selected 6 decisions, which in my view are the highlights worth presenting. The first 3 decisions I will discuss were issued further to applications to set aside the award. Then I will turn to 1 decision on the revocation of the award. And finally, I will summarize 2 decisions on the enforcement of an award in Switzerland. So let's start with the applications to set aside. The first decision I will discuss is interesting because it deals with an unreasoned award issued by a rabbinical arbitral tribunal. The facts, very, very briefly, 3 parties entered into an agreement in order to solve their dispute in relation to a real estate investment by a rabbinical arbitral tribunal. And the agreement expressly stated that Jewish rules of procedure would apply, as well as Jewish secular and Jewish rules. The arbitral tribunal held a hearing, and after this hearing, it issued an award in favor of the claimants. The award contained only the operative part, so only the decision at the end. It did not contain any reasons, no findings of fact, and no outline of the proceedings. The Federal Supreme Court first examined the decision issued by this arbitral tribunal in order to determine whether it amounted to an award that may be challenged. Now, Swiss law does not define an international award within the meaning of Article 189 PILA. However, according to the cases decided by the Supreme Court, an award within the meaning of this provision exists where a decision is issued on the basis of a valid arbitration agreement by a non-state court entrusted by the parties with the resolution of a dispute with a pecuniary interest, and finally, with an international element. In this case, the Federal Supreme Court held that all requirements were met, meaning that the decision was to be regarded as an arbitral award which may be challenged. However, the court also held that while religious courts are prohibited, at least under the Swiss constitution, this prohibition does not apply in circumstances where the parties freely agree to submit an arbitrable matter to a religious arbitral tribunal. Here, even if the case concerned an arbitral award issued in an arbitrable matter by independent and impartial arbitrators, the court then explained why it could not review the award. In Switzerland, the rules of procedure applicable to the arbitration, as well as the rules governing the form and content of the award, are subject to party autonomy. So depending on the rules that the parties choose, this may lead to problems when it comes to challenging the award or enforcing the award. And let me give you an example. If the award is issued only orally, or if it need not be reasoned, these circumstances may significantly reduce the effectiveness of a challenge. And in order for the court effectively to review the challenged award, it also requires findings of fact on the arbitration proceedings and on the merits. It is not for the court. The Swiss Federal Supreme Court will not look for these elements in the file, even if these elements are not challenged between the parties. In this case, the court considered that depending on the rules of procedure agreed upon between the parties may well face an award which is, in principle, subject to challenge before the Supreme Court, but the review of such award would be de facto limited or even entirely excluded. Here, the court noted that the parties referred to the Jewish rules of procedure, which place much emphasis on the principle of orality. And as the court was left only with the operative part of the award, it concluded that it could not review the award, and the application to set aside was therefore rejected. Now, this decision is interesting because it emphasizes how Switzerland's liberal approach to party autonomy could lead to perhaps unintended consequences. The parties are free to agree on the rules of procedure of their choice. They may also agree that the award should be issued only orally, or that the award should not contain any reasons. This is perfectly possible as a matter of Swiss law. However, the parties should be aware of the consequences of their choices. Now, I'm leaving aside the example of the award issued only orally, which is an extreme example. Agreeing on a procedure which leads to a written award containing only the operative part, without reasons and without the outline of the proceedings, will almost certainly de facto preclude an effective challenge of the award. There may be an exception. For instance, if the challenge is based on the ground that the arbitral tribunal lacked jurisdiction, there maybe, even if you just have the operative part of the award, the Supreme Court might effectively look at the jurisdiction of the arbitral tribunal, but that is clearly the exception. The second decision I will now turn to was issued in a sports matter. And this was the only challenge in which the award was set aside by the Federal Supreme Court last year. It deals with the challenge of an arbitrator, his duty to make disclosures, and the party's duty to make their own inquiries. So the facts. An Austrian citizen was hired as a coach by a Croatian football club, and that club was member of the Croatian Football Association, which in turn is member of the FIFA. The coach and the club entered into an employment agreement, and this employment agreement contained a reference to the arbitral tribunal of the Croatian Football Federation. What happened next is that the club terminated the employment agreement and the coach sued the club before FIFA's Players Status Committee. The club raised a jurisdictional objection, claiming that it was the arbitral tribunal of the Croatian Football Federation who was the body of competent jurisdiction. The FIFA Players Status Committee declared that it had jurisdiction and partially granted the coach's claim. And this is the decision that was challenged then by the club before the Court of Arbitration for Sport, the CAS. The Croatian club designated a Croatian lawyer as its arbitrator. And what happened next is that during a deliberation session, it emerged that this Croatian lawyer, arbitrator, was one of the 12 arbitrators appearing on the list of arbitrators of the arbitral tribunal of the Croatian Football Federation. Upon receiving advice by the CAS, the arbitrator made a declaration, made a disclosure. On the following day, FIFA challenged this arbitrator, and the arbitrator was ultimately removed from the CAS panel following a decision by the Challenge Commission of in the International Council of Arbitration for Sport, the ICAS. The club designated a new arbitrator, and the CAS panel, which was formed, which was composed, which included this new arbitrator, eventually rejected the club's appeal. Turning now to the decision. The petitioner here, so the club, challenged the award on the basis that the CAS panel was irregularly constituted because the CAS wrongly accepted the challenge against the Croatian arbitrator, which it had designated. In Switzerland, but not just in Switzerland, an arbitral tribunal must be composed of impartial and independent arbitrators. Here, the Supreme Court recalled that in order to assess the arbitrator's independence, resort may be had to the IBA guidelines on the conflicts of interest. So the court does not consider these guidelines as having the same force as laws, but it compares them with rules of ethics which may be used in order to interpret professional rules. The specific circumstances of the case will always be decisive, but the IBA guidelines are regarded as a quote-unquote useful working tool. Since the revision of the Swiss law of international arbitration, which entered into force on 1st January of 2021, there is now a new provision, Article 179, paragraph 6, which requires any arbitrator to reveal circumstances which may raise justifiable doubts as to his or her independence or impartiality. However, this duty covers only facts which the arbitrator reasonably considers to be unknown to the parties. Also, according to Swiss case law, the simple fact that an arbitrator failed to make a disclosure is not per se sufficient in order to challenge him or her. It is also important to note that, as a matter of Swiss law of arbitration, a party which intends to challenge an arbitrator must do so immediately. Failure to raise the challenge immediately entails the forfeiture of the right to challenge. The Federal Supreme Court also recalled its consistent case law, whereby parties cannot simply accept the arbitrator's statement of independence and impartiality, the document that needs to be signed by any arbitrator in institutional arbitration. So the parties cannot simply accept that. They also have a duty to make their own inquiries. Now, they don't have to scan the entire internet to make these inquiries, but they are required, at least from the standpoint of Swiss arbitration, they are required to at least look at the main platforms, usually on the internet, platforms which are susceptible to contain relevant information as to the arbitrator's impartiality and independence. With these considerations in mind, let's look at the concrete case. The court found that the CV of the challenged arbitrator was freely accessible on the website of the CAS, and it also mentioned expressly that he was among the arbitrators of the arbitral tribunal of the Croatian Football Federation. So therefore, he did not need to make a disclosure because the parties were reasonably supposed to know what was in the arbitrator's curriculum vitae. And then on the other hand, FIFA breached its duty to make inquiries. It did not challenge the arbitrator immediately, and therefore it lost its right to challenge him. And so for these reasons, the court quashed the award. This decision, in my view, serves as a good reminder of the arbitrators and the parties' duties in relation to disclosures and challenges. So the first point is that it is important to note that the Federal Supreme Court will use the IBA guidelines, at least as a working tool. Looking at the arbitrator, he or she is required to disclose only facts which are reasonably unknown to the parties. And a failure to disclose, to make a disclosure does not necessarily mean that the arbitrator may be successfully challenged. And then finally, the parties, they cannot stand idle. They also have a duty to make reasonable inquiries. And if they fail to do so, and if they fail to challenge the arbitrator immediately, they will lose their right to challenge the award before the Federal Supreme Court. The next decision I will discuss relates to a dispute between the Republic of South Sudan and two companies. It deals with the validity of an arbitration agreement and whether such agreement is binding on a new state. Now, before I go into the details, I should draw your attention to two provisions which are relevant here. The first provision is Article 177, paragraph 2 of the PILA, according to which, and I quote, a state or an enterprise held by or an organization controlled by a state that is a party to an arbitration agreement may not invoke its own law in order to contest its capacity to arbitrate or the arbitrability of a dispute covered by the arbitration agreement. The second provision I wish to mention is Article 178, paragraph 2 of the PILA, which governs the substantive validity of an arbitration agreement. It provides, and I quote, that an arbitration agreement is valid if it conforms either to the law chosen by the parties, to the law governing the subject matter of the dispute, in particular the law governing the main contract, or to Swiss law. Now, the facts, very, very briefly. This dispute arose between two companies and the Republic of South Sudan in relation to a license agreement under which the companies were to set up a telecommunications network in the territory which later became South Sudan. The license agreement and its amendments were dated 2003, 2007, and on 9 July 2011, the Republic of South Sudan gained independence from the Republic of Sudan. Later, in 2018, the two companies brought arbitration proceedings against the Republic of South Sudan, relying on the arbitration agreement set out in one of the amendments to the license agreement. And South Sudan raised a jurisdictional objection against the sole arbitrator. The sole arbitrator issued a partial award where he declared that he had jurisdiction, and he also decided on the principle of liability among other issues. Turning to the decision of the court, the Federal Supreme Court, the court first confirmed that an arbitration agreement is valid from a substantive standpoint if it conforms with one of the systems of law set out in the provision that I just mentioned, so 178, paragraph 2. There is no hierarchy between these systems of laws. However, what the court clarified for the first time is that one cannot mix these systems of law. So in other words, it is not admissible to cherry pick one requirement from one system of law and another requirement from another system of law. You have to take one of these systems of law, take their requirements, and check whether the arbitration agreement is valid from a substantive point of view according to one of these systems of law. So this is perhaps the first important point mentioning. Now, one of the arguments of the petitioner, so South Sudan, was that the persons who had signed the arbitration agreement in dispute had no authority to do so. Here, the court, the Federal Supreme Court, referred to Article 177, paragraph 2, which we also saw a short while ago, and held that this provision also excludes that a state can rely on its domestic law in order to argue that a person did not have authority to enter into the arbitration agreement in dispute. So, and this is all the more so where the other side, so the claimant companies in this case, acting with the diligence required, could not have evinced the lack of authority. And then we're moving to the core of the subject of this decision, which is the argument by South Sudan that it did not, that the arbitration agreement did not become binding on South Sudan following the independence in the year 2011. The court found that South Sudan was indeed bound by the arbitration agreement on the basis of three considerations. Firstly, South Sudan and the Republic of Sudan, so the two states, entered into a so-called economic agreement on 27 September 2012, providing that, and I quote, "The two states shall treat domestic assets and liabilities in accordance with the territorial principle, by which assets and liabilities that have a domestic connection to the territory of Sudan shall be allocated along territorial lines and attributed to the respective state." So as the license agreement covered the territory of South Sudan, this agreement passed on to the Republic of Sudan. The second consideration is that by a ministerial order dated 1st November 2012, South Sudan expressly confirmed that telecommunication operators, and among which one of the two claimants in the arbitration, that they were deemed accepted as licensed telecommunication operators within South Sudan. Quote, "under the terms and conditions of their original licenses issued by the Republic of Sudan, whereas the Republic of South Sudan is acting as legal successor of the telecommunication corporation within the territory of South Sudan." Thirdly, and this is the final consideration, the Federal Supreme Court noted that after South Sudan had gained independence, South Sudan continued its relationship with the claimant companies under the license agreements and expressly acknowledged that it would honor them. So the agreements and the amendments. And so therefore the court concluded that the license agreement and its amendments became binding on the Republic of South Sudan. This decision is important, in my view, because it confirms that states or state-controlled entities cannot rely on their own domestic law in order to challenge the authority of the persons who signed the agreement containing the arbitration clause. This decision is also a rare example of an arbitration agreement becoming binding on a newly created state. Although I have to say that this decision was somewhat made easy because of the economic agreement between the Republic of South Sudan and the Republic of Sudan, and the express statements of the South Sudanese authorities, which clearly indicated that South Sudan would honor the agreements in dispute. So I will now turn to a decision issued further to revocation proceedings. And the dispute is a dispute between the Republic of India and Deutsche Telekom. India sought to revoke the awards issued by the arbitral tribunal. Now here, before I go into the details of this decision, I need to make a step back and give you some context. At the end of the 1990s and the beginning of the years 2000, the Indian government introduced a new policy in order to encourage investments from the private sector into its space industry. And one of the objectives was to create a hybrid communication platform combining satellite and terrestrial technology. A private Indian company named Devas Multimedia Private Limited was created for this very purpose. In 2005, Devas entered into a contract with another company, Antrix Corporation Limited. This is a state-owned entity, whereby Antrix leased to Devas the S-band electromagnetic spectrum capacity to be provided by two satellites. In 2008 and 2009, Deutsche Telekom made two rounds of investments in Devas through a Singaporean subsidiary. And what happened in the following years is that the project underpinning the contract between Devas and Antrix was abandoned, and in February 2011, Antrix terminated the contract with Devas. Antrix relied on the decision taken earlier that month by the Indian Cabinet Committee on Security not to provide Antrix with the S-band electromagnetic spectrum capacity for commercial purposes. In 2013, Deutsche Telekom brought arbitration proceedings against India before the Permanent Court of Arbitration on the basis of the Germany-India Bilateral Investment Treaty, the BIT. The seat of the arbitration was in Geneva. There is a first decision of the arbitral tribunal, an interim award dated 13 December 2017, in which dealt with India's jurisdictional objections and the principle of liability. The tribunal concluded that it had jurisdiction and that India had breached the fair and equitable treatment rule in Article 3.2 of the Germany-India BIT. In the year 2017 or 18, India sought to set aside the interim award before the Federal Supreme Court, but was not successful. Now, I will not go into details of that decision, but I will simply mention that one of the arguments that was advanced by India at the time was that the contract between Devas, the object of the investment, and Antrix, the state-owned company, was tainted by illegality. And here I'm summarizing the Supreme Court found inter alia that this jurisdictional objection was raised belatedly by India. And it also recalled that in any event, any complaints made in relation to the promise to pay, the promise of an improper payment are admissible before the Federal Supreme Court, only provided that corruption was proved and that the arbitrators failed to consider this point in the award, which was not the case. The arbitration proceedings continued. On 27 May 2020, the arbitral tribunal issued its final award, ordering India to pay damages in an amount of 93.3 million US dollars. And what is important to note is that this award was not challenged with setting aside proceedings in Switzerland. And then on 2 May 2022, India filed an application for revocation against the interim award and the final award on the basis of the discovery of new facts and evidence. Turning now to the decision of the Supreme Court, there is one important consideration which I wish to summarize here, and it pertains to the moment when the petitioner becomes aware of new facts and evidence within the meaning of Article 190A(1)(a) of the PILA. And what is relevant also here is that under Swiss law, an application for revocation must be made within 90 days since the ground for revocation was uncovered. So what was India's argument here? India contended that it had sufficient knowledge of the ground for revocation since 17 January 2022. That date is the date when the Indian Supreme Court issued its decision ordering the liquidation of Devas, so the object of the investment. The Federal Supreme Court did not follow this argument because it considered that the proceedings before the Indian Supreme Court were preceded by two instances. The first instance proceedings were decided by the so-called National Company Law Tribunal, which already ordered the liquidation of Devas on 25 May 2021. And then there was a second instance before the National Company Law Appellate Tribunal, which also ordered the liquidation of Devas on 8 September 2021. And so the Federal Supreme Court, the Swiss Federal Supreme Court, held that India had knowledge of the facts already on 25 May 2021, which is when the National Company Law Tribunal issued its decision. And so what is relevant is the knowledge of the facts by the applicant and not the determination of those facts by a judicial authority, and let alone the final decision issued at the end of the judicial process. Finally, the court also held that the petitioner could not rely on the decision by the Indian Supreme Court as new evidence, because Article 190A(1)(a) expressly excludes facts and evidence which occurred after the award was made. This decision is important insofar as it confirms that the event triggering the time limit for revocation proceedings with regard to new facts and evidence is the moment when the applicant has sufficient knowledge of the new facts so as to rely on them, even if it cannot bring strict proof. So mere suspicion is not sufficient. Now here, of course, there is a fine line to be drawn between suspicion and having sufficient knowledge of the ground for revocation. This will have to be determined on a case-by-case basis. However, what is clear is that the applicant must not and should not wait until a decision by a judicial body or another body, and certainly not wait until the decision becomes final and binding after the exhaustion of all means of recourse. I'm now moving to the fourth decision, which relates to the enforcement of awards in Switzerland. Here, the first decision I will turn to concerns a dispute between company A and the Kingdom of Spain. It concerns the attachment of assets in Switzerland belonging to a foreign state based on an ICSID award. So the facts are quite easy to summarize. A company A sought an attachment order against Spain for to secure a sum of some 33 million Swiss francs. And this request was based on an ICSID award dated 6 September 2019. Regional appeals did not change the situation, and so the matter was later brought before the Federal Supreme Court. Now here, the Federal Supreme Court dealt with two issues. The first is the manner in which an ICSID award must be treated in Switzerland. And secondly, the court examined the requirements for an order for the attachment of assets against a state. As to the first issue, the court recalled that the applicant, which relies on a foreign decision, must show at least prima facie that such decision is capable of being recognized and enforced in Switzerland. And foreign arbitral awards are recognized and executed in Switzerland in accordance with the New York Convention. This is expressly set out in Article 194 of the Private International Law Act. The court then referred to Article 7(1) of the New York Convention, according to which its provisions shall not affect the validity of multilateral or bilateral agreements concerning the recognition and enforcement of arbitral awards. And here, the ICSID Convention is one of such multilateral agreements. And the provision in point of the ICSID Convention is Article 54. And you see on the slide paragraphs 1 and 2. Paragraph 1 provides that each contracting state shall recognize an award rendered pursuant to this convention, the ICSID Convention, as binding and enforce the pecuniary obligations imposed by that award within its territories as if it were a final judgment of a court in that state. And so this provision does not call for any review of the award. Swiss authorities may not even review the award on public policy grounds. The second paragraph of Article 54 provides that a party seeking recognition or enforcement in the territories of a contracting state shall furnish to a competent court or other authority which such state shall have designated for this purpose a copy of the award certified by the Secretary General. And so on the basis of Article 54 of the ICSID Convention, the Federal Supreme Court concluded that the applicant needed to provide only a copy of the award certified by the Secretary General in order to pass the prima facie test. Then the court turned to the specific requirements in order to attach assets of a foreign state. And what the court did first was to summarize its standard requirements. And these are three requirements. Firstly, the foreign state must not have acted in a sovereign capacity. It must have acted as a holder of private rights. Secondly, enforcement measures against a foreign state require that the relevant legal relationship has a sufficient connection to Switzerland. And then thirdly, the final requirement is that assets of a foreign state located in Switzerland that serve sovereign purposes are excluded from enforcement proceedings. This decision concerned more specifically the second requirement, so the sufficient connection to Switzerland. The Federal Supreme Court recalled that under Article 54, paragraph 3 of the ICSID Convention, the execution of the award shall be governed by the laws concerning the execution of judgments in force in the state in whose territories such execution is sought. And so this means, according to the Federal Supreme Court, that its own requirements remain valid because the ICSID Convention makes reference to the domestic states where the enforcement is sought. And so this includes also the requirement that the requirement of the sufficient connection to Switzerland. So when is this requirement met? It is met when the legal relationship from which the request for attachment arise was established in Switzerland, or if it is to be fulfilled there, or if the foreign state has at least taken some kind of actions in Switzerland that establish a place of performance. And so it is not sufficient that assets of the state are located in Switzerland, and it is also not sufficient to claim that the award was issued by an arbitral tribunal seated in Switzerland. What the petitioner tried to do here is that it relied on Article 74(2)(1) of the Swiss Code of Obligations, which provides that pecuniary debts must be paid at the place where the creditor is resident at the time of performance. And understand that there is a similar provision in Article 89(1) of the Turkish Code of Obligations. The Federal Supreme Court did not follow this argument for the following reasons. It referred to Article 42(1) of the ICSID Convention, which says that an arbitral tribunal must apply the rules of law chosen by the parties. Now, in the present case, the dispute was subject to the Energy Charter Treaty, the ECT, which provides in Article 26(6) that disputes must be decided in accordance with the ECT and international law. And petitioner in this case did not show that the rule in Article 74 of the Swiss Code of Obligations is part of the ECT or international law. So here the key takeaway, I would say, is that the attachment of assets of a foreign state based on an ICSID award would follow the standard requirements established by Swiss courts. And this includes the requirement of the sufficient connection to Switzerland. The final decision I will discuss also deals with the attachment of assets of a foreign state. Here, what happened is that the petitioner, a company established in Panama, obtained a favorable award against a company from Uzbekistan. And this award was issued by an arbitral tribunal seated in Switzerland. Now here, in a very peculiar way, the Republic of Uzbekistan guaranteed the execution of this award by signing a document which stated, and I quote, you can see it on the slide, should the debtor not entirely pay the debt by the end of 2017, the creditor is entitled to seek payment by way of debt collection proceedings and, if necessary, even to seize the debtor's assets in Switzerland. The judge ordered the attachment, and the matter was then brought before the Federal Supreme Court. Now here, it's just to put some context, it was not disputed that the Republic of Uzbekistan was acting as a holder of private rights, not as a sovereign entity, such that the immunity against enforcement did not need to be discussed in this specific case. Here, one of the main topics of the decision was whether the document that I quoted from above created a sufficient connection to Switzerland. And here, the Federal Supreme Court validated the reasoning of the lower courts, which was essentially this. It was not sufficient that the award itself had its seat, was issued by an arbitral tribunal with its seat in Switzerland. That was not enough. However, the document that I quoted from before did establish such sufficient connection because it specifically referred to attachment of assets of the Republic of Uzbekistan in Switzerland. So this decision is very peculiar because it almost entirely relies on this guarantee of this document that was signed by the Republic of Uzbekistan in order to guarantee an award, the payment further to an award issued against a company of Uzbekistan. So, of course, if there is such a document, the sufficient connection to Switzerland requirement is likely to be declared as fulfilled. So that was the end of my presentation. I thank you for your attention, and I'm looking forward to questions.
Thank you very much, Dr. Durante. It seems that likelihood of success for setting aside or revocation of cases is in Switzerland is nearly zero.
Yes, yes. I think that last year was even particularly harsh because the previous years usually you would have at least maybe 2-3 awards being set aside. So last year was a bad year for those who wanted to set aside awards.
It is important to note that really that fact. A few years ago, I was writing an article, and I have gone through Swiss scholars on setting aside and revocation, and in that date, they refer to 10%, below 10% of the cases could be set aside or revoked in Switzerland. So it seems that in this aspect, Swiss Federal Court goes more liberal. Let's put it this way.
Yes, yes, there are a few articles on the statistics for the previous years, and you're right that on average, so without counting just 2023, but it's on average, it's the success ratio is yes, slightly below 10%, and it's typically jurisdictional objections, which are the few cases where an award is set aside.
Wonderful. So in light of these cases that you have gone through, how would you consider Switzerland as a leading arbitration venue?
Well, I think that what these 73 decisions, because I had to read them all, what they confirm is that Switzerland really has a very liberal approach to arbitration. But of course, I think that then this comes with pros and cons. Again, as I said before, in Switzerland, the parties can agree to have an award issued only orally. Now, this is very well on paper, and again, it would be considered valid at least here in Switzerland. But how can you enforce an oral arbitral award? I mean, it would effectively be impossible, and so would be the setting aside proceedings against such award. So these are maybe the extreme examples, but in general, I would say that the Federal Supreme Court confirmed in all decisions that party autonomy is the name of the game, with all the consequences that might derive from that, and that once you agree on arbitration, and once the jurisdiction of the arbitral tribunal is ascertained, then it is extremely difficult to set aside the award later. So it is very important for the parties to make sure that they really put forward all their arguments before the arbitral tribunal, because the Federal Supreme Court will not come to their rescue, save for, again, exceptional cases. But again, you mentioned the statistics before, so the chances are quite slim.
Yes, it's very striking that even for an award without reason, the Swiss Federal Court did not use public policy reasoning.
Indeed, this is yes. It's while that decision had some novelties in it, it's actually been consistent case law of the Supreme Court that the right to due process of the parties does not include a reasoned award. So according to the Federal Supreme Court, if a tribunal issues a decision without reasons, the parties cannot say, "I've not been heard, and my right to due process was breached" on that argument alone.
Thank you very much, Dr. Durante. We are grateful to you for this excellent presentation and comments. We are also grateful to Turkish Arbitration Academy for their support. See you for next time.